As always, the views expressed during today's webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered an experienced panel to provide a thorough guide to the nuances of pre-immigration tax planning, offering practical tips to help assist high net worth client transitions into the U.S. in a tax-efficient manner. Our panel today includes Anthony Corda, an attorney with the Corda Law Firm. He's joined by Richard S. Lehman, an attorney with United States Taxation and Immigration Law. Anthony, when you're ready, we'll go ahead and get started.
Thank you very much. Well, depending on where you are and where you're listening from, good morning, good afternoon, and good evening. I think I feel like David Frost saying that, but let's start straight away moving forward. You can read the biography about me. I'm an immigration attorney originally from the UK, focusing my practice now on business immigration and in particular EB-5 visas. Richard obviously is the tax attorney, and so he's going to be speaking about tax issues. I'm really going to just introduce tax issues as they apply to the immigrant and non-immigrant visas, and also to discuss to some extent the EB-5 program and alternative tax credits. On the first slide there, we can see examples of some non-immigrant visas. These may be visas that you or your clients are familiar with. L1 intercompany transfer visas for people who want to come to this country for a temporary basis up to 7 years, acting as managers or executives. Treaty trader and treaty investor visas under the E program, and H visas, temporary workers. Contrast that with immigrant visas, in particular the EB-5 immigrant investor visa that we're going to be discussing today. Alternatives EB-1 multinational manager or executive, which is very similar to the L1 visa, but obviously is immigrant-based. And then there'll be others. And the relevance, I think, of that slide is that there is a difference, clearly a distinction between the tax treatment of immigrants and non-immigrants, which ultimately is going to be discussed in more detail by Richard. One thing to note is that the immigration laws of the United States refer to aliens as immigrants, non-immigrants, and undocumented aliens. The tax laws of the United States refer only to resident and non-resident aliens, and so you can qualify as a resident for tax purposes without necessarily qualifying as a resident for immigration purposes. The two are distinct tests, and people find themselves in many cases liable to U.S. tax, even though that was an unintended consequence, where they hadn't intended either to be a resident of this country or at the very least a tax resident. And so residents for immigration purposes and residents for tax purposes are not the same. There are different tests, and these are going to be looked at in more detail during the course of Richard's presentation. So let's talk about the EB-5 investor visa. EB-5 investor visa program has been around since 1990. It's been, I think, the subject of some problems early on in its concept. There seem to have been some frauds and some perceived frauds. And so the U.S. government and USCIS suspended the program. The current EB-5 program has really been with us since about 2005, 2006. Although it's taken off more recently, really since about 2011, 2012, when the Chinese market has really dominated EB-5. The EB-5 investor visa program is a permanent program to the extent that it deals with direct investments. I'll just explain that. Direct investments are where the investor invests directly into the vehicle, the investment vehicle, and the investment vehicle will employ the required employees directly. Contrast that with the Regional Center Pilot Program. The Regional Center Pilot Program has permitted regional centers to be set up to invite effectively pooled investment. It has been quite successful. There are now more than 800 regional centers throughout the United States, I think pretty much in every state. These will attract investment into the state by putting together investment projects that might otherwise not be financed, but certainly that will be able to pool the finance of a number of investors. And there are some big advantages to the regional center. The main advantage to the regional center is that it permits indirect employment to be counted. I'll put that into perspective in a moment. whether it's direct investment, whether it's the regional centre pilot program, there are three things that the investor and also the promoters must show. Firstly, as far as the investor is concerned, that the investor is otherwise admissible. Despite all the publicity that one hears from those people who criticize the program, people who invest in the EB5 program are very heavily checked, background, their source of funds, and really everything about them, so that they must be otherwise admissible. It's not simply an easy way for people to find access to this country. If you are otherwise admissible into the United States and you have a minimum investment amount of $1 million, you can invest that into a direct investment or indeed into a regional centre pilot program, and provided you can show that within a reasonable period, which is determined to be around 2 years after conditional residence ends, that you have created 10 new jobs, then ultimately the investor will be successful. Now, because the regional centre pilot program and also the EB5 program were designed to try and attract investment into high unemployment areas, an incentive was provided whereby if you invest into a rural area or a targeted employment area, which is an area in which there is unemployment level of 1.5 times the national average, then the minimum investment amount is going to be reduced to $500,000. Obviously, investing $500,000 is more attractive than investing $1 million, particularly since these investments must be what are called at risk. Once approved, the investor's spouse, and any unmarried children under 21 receive permanent residence, green cards for short, and there's an initial residence period of 2 years. At the end of that 2-year period, the investor must show, with the assistance of the project, that the investment was made, that the investment was sustained, and that those jobs that were ultimately to be created, the minimum amount of which is 10, have actually been created or will be created within a reasonable period. The advantage of the regional centre pilot program, as I've already indicated, is that indirect employment is permitted. As anyone who I think deals with businesses will agree, to try and create 10 jobs with an investment of $500,000 or even $1 million can be quite difficult. And so to ameliorate that, the regional centre program permits indirect employment, induced employment, if you like, to be counted. And what happens is that at the beginning of the process, the project will obtain an economic report. They'll hire an economist who will provide an economic report based on one of a number of economic multipliers or calculators that were already in existence prior to the EB5 program, IMPLAN, RIMS2, those sort of things, REDINE, and will effectively plug into whatever those multipliers are, the investment amount, the type of industry, the location, and will calculate how many jobs will be created indirectly as a result of that investment. And that has two big advantages. Firstly, from the promoter's point of view, they don't have to go out and actually hire anybody directly, or if they do, they don't need to maintain strict records for the purposes of USCIS, the immigration service. Instead, they simply show that they haven't obtained the economic report, that what was supposed to have happened happened, and that ultimately these jobs are deemed to exist. The other advantage is that most of the regional centres have been set up in areas that have qualified as targeted employment areas. So pretty much every regional centre project that's available out there is going to be at the lower investment amount. I've already indicated the initial residence period for an investor is going to be 2 years. The advantage to the promoter, the project promoter, is that this is a cheap form, if you like, of inexpensive mezzanine financing that might otherwise not have been available. But particularly in 2008, 2009, and so on, when we were experiencing the worldwide recession, the banks were not lending money. It was impossible to find institutional finance. This was a very cheap and easy way to obtain non-recourse financing for projects that might otherwise never have got off the ground. Now, when this was first popular again in about 2006, 2007, it was very quick. You could invest your money into a project, you could apply for your benefit, and USCIS would process these regularly in less than 90 days. unfortunately, because it's now so popular and because so many people have got on the bandwagon, particularly given the Chinese market, it's taking at least 2 years now, sometimes more, for people to be processed. And there seems to be a large backlog of visas and a large backlog of investors waiting for their green cards to come through. The other limitation is that there are only 10,000 investor visas available annually, and those 10,000 will include not just the investor but the spouses and any unmarried children who are also going to be taking advantage of the benefit. And so we're finding, certainly more recently, that the visa allocation is being used up very, very quickly, and then there are further delays. As I've already indicated, because of the Chinese market, they have immigration agents who found themselves without a place to send their clients when the Canadian program shut down. Canadian agents have made the American program very, very successful, but unfortunately have flooded the market, and so visa wait times have now been brought in for mainland Chinese nationals, which will mean that the processing of their visas can now take many, many years, and so it's no longer for the Chinese an immediate visa category as it was initially. As I've already indicated, these people must be otherwise admissible. One of the things that they have to show is that they have a lawful source of funds. The funds which they invest can come from any source. They can be income investment, they can be profits, gifts, bequests. Loans are slightly more complicated. The loans must be secured on assets owned by the investor, and the investor will have to show how he or she acquired the asset that's being used for security. That's probably the biggest part of the EB-5 processing. In other words, the USCIS are going to be looking individually at the investor, but also at the investor's source of funds. And provided the investor can show a lawful source of funds, then ultimately he or she will be able to satisfy USCIS that their initial I-526 petition, which is the petition that's filed, should be approved. The project must also meet the requirements of EB-5 regulations. It's now possible to file what's called an exemplar application. So if you're acting or working with a developer who wants to make sure that the project itself is going to be approved prior to filing an actual EB-5 investor petition, then that can be done, and that's obviously going to be very successful for marketing purposes. It also means that if there are any problems with the project as far as USCIS are concerned, these can be resolved before individual investor petitions are going to be looked at. The project, as I say, must create 10 new full-time jobs. There's no requirement for these jobs to be professional jobs or management jobs or any other kind of job. In fact, they can be minimum wage or more, 35 hours per week or more. That will satisfy the job requirement. Congress has stated an intention to raise the minimum amounts. But the problem that we have in the EB-5 industry at the moment is that the regional center part of it, which is effectively the biggest part of it, 95% or so of investors, maybe 90% now, are investing in regional center projects because these are effectively passive investments to the extent that the investor doesn't have to get involved in the day-to-day management of the business. And so the regional center program is a pilot program. It keeps sunsetting and being extended. The program itself actually sunset, or was due to sunset, in July of 2015. It's been extended several times since then by 3 months, 6 months, and 9-month increments. And more recently, we've been tagged on to the continuing resolution, which keeps Congress effectively financed and funded. And so the problem that we have is that we have deadlines, which mean that people suddenly panic and decide they must do this. I think December the 8th was the last deadline, then it was extended into January, and now currently it's going to be expiring again on May the 28th with the continuing resolution. We don't know when or if Congress will in fact raise the minimum amounts because, as I'm sure you're all aware, Congress are not in agreement on very much at the moment, let alone anything to do with immigration. And although there is, on the whole, bipartisan agreement that the EB-5 program should continue and that the minimum investment amounts, which have been the same since 1990, should be increased, they don't seem to be able to do anything about it. USCIS, I think in an attempt last year to try and force Congress to act, published regulations that said if Congress don't increase the minimum investment amounts, then USCIS will do so by regulation, which they do seem to have the power to do. And if it's left to them, they will increase the minimum investment amounts from 500,000 to 1.35 million and from 1 million to 1.8 million. In addition, they're going to earmark a certain amount of visas for different categories, some for targeted employment areas, some for not targeted employment areas. If these proposals go through, it's going to be very difficult for people, I think, to find clients who want to invest in the projects, not least that it's going to be very difficult for USCIS to try to figure out how it is they're going to process all of these different applications at different rates. One of the craziest parts of this, I think, a couple of years ago when this was first mooted by Congress, they wanted to raise the minimum investment amounts and they wanted to backdate it by a year, which would have meant that everybody who had previously invested in projects on the assumption that the minimum investment amount was $500,000 would now be denied unless they increase their investment. And so we're hoping that at some point Congress will sensibly raise the amounts maybe to no more than $1 million from 500,000, maybe a little bit less than that, and that they will also make the program either permanent or give us an extension at least or renewal for 5 years or more so that people will have some certainty. But as I say, at the moment we don't have that. There are also going to be changes in the way that targeted employment areas or rural areas are going to be determined. It must be said that one of the reasons that the reduced investment amount was created for the EB-5 program was to encourage investment in high unemployment and or rural areas, which were traditionally also high unemployment. That's manifestly not been the case. I think with very few exceptions where projects just happen to be located in rural areas, there's been a lot of fudging, rather like with elections, gerrymandering. What you can do is you can take a number of census tracts and aggregate them, and if the average of that area is 1.5 times the national average of unemployment, then you can still qualify as a targeted employment area, even if the actual location for the project does not. Now, some people think, well, that's not really a problem because you're not just going to get employees from the area in which you're located. People are going to come from outside, especially in high unemployment areas. Other people take the view, this is actually not doing what it's supposed to do, particularly politicians whose constituents are rural and who are finding that they're not getting the investors that they had hoped they would get. And so, again, USCIS have got involved in this, Congress are getting involved in this. The idea is to change the way targeted employment areas are going to be determined, possibly by as few as one census tract, and secondly, that USCIS will be the agency that will determine, whereas at the moment it's the state agencies and the local agencies are able to determine whether something qualifies as a targeted employment area or not. I hope it's not USCIS that's going to be doing this because they already seem to be overworked and unable to cope with the duties that they have. There's no real difference in leaving this to the state agencies who have worked with this quite efficiently for a long time using Department of Labor figures. So we're hoping that that won't change. But certainly the three things that you see are important there. One, minimum investment amounts. Two, the targeted employment area, and three, the other big change we hope is the number of visas, that Congress either earmarks more visas for EB-5 or alternatively determines that only the investor comes out of the 10,000 visa allocation and that the family members come out of other visa allocations that are already available. That really introduces new market and other tax credits. There are some similarities. Obviously, the EB-5 program with the reduced investment amount was intended to try to encourage investment in high unemployment areas. I think, without being too controversial, that's just not happened. If you're trying to sell an EB-5 project to an investor in China, they know where New York is. They know where Fifth Avenue in New York is. They know, Trump Towers and other buildings. And if you say, well, our project is going to be located in Fifth Avenue in New York, or it's going to be located in the famous area in Chicago, somewhere they've heard of, something in Miami, then it's going to be easier to sell that than to say, well, we have a farm in rural Iowa. Would you like to invest in that? And so, again, to try and create a level playing field, Congress are going to have to act in a way that will probably mean that these more glamorous projects will simply disappear. They won't qualify. But to the extent that there are tax credits available, obviously the new market tax credit is one of the most obvious, $3.5 billion allocated annually. One of the big advantages, if it does qualify for a new market tax credit, is that the developer will be entitled to up to 39% in total tax credits earned over 7 years. But rather like the EB-5 program, investment must be made in low-income community areas. There's a body, the community development entity, that makes the investment, and ultimately it is proved, I think, rather difficult to effectively do this with EB-5. I think for the reasons that I've already outlined. One, because EB-5 doesn't generally want to invest in these kind of areas, and two, because, I'm going to advance one more slide actually, because allocations are hard to find. There's a 7-year holding period which may be inconsistent with the term that's required under whatever the agreements may be, and also what is required for the EB-5 program. And there will be conflicts and complications with others in the capital stack who may want earlier repayment than is permitted under the EB-5 regulations. High costs and complicated structures have also meant that it's just not been something which EB-5 developers have been looking to. The advantages, though, if it does work, is it can be added to the capital stack with private equity, public financing, or EB-5 capital. In other words, in addition to inexpensive mezzanine financing through EB-5, capital developers can also take advantage of tax credit financing to generate greater returns. This may make the difference in some cases between whether or not an underfunded or otherwise underfunded project is feasible or not. So in some cases, I think there's a big advantage to trying to look at new market tax credits is first of all to consider whether or not the EB-5 program is suitable for the particular type of investment given the location, and then to see if the new market tax credits would apply. It's almost as if the new market tax credits would be an added incentive, but it's not something which is going to necessarily mean that an EB-5 project will come to that area. There are other tax credits also which are not on my slide, but which you might want to look at if you're going to be doing research into this area. There's a low-income housing tax credit which is determined to fund development of low-income housing and affordable housing in certain areas. Again, it's not impossible that that could be linked together with an EB-5 project, but not very many EB-5 projects at the moment are looking to develop low-income housing. For the reasons I've outlined, investors would prefer to have, penthouse suites in Fifth Avenue, New York, than they would to necessarily go into affordable housing. And despite the tax credits, it's an issue of also whether or not the investors are going to see a return on their investment as well as a return of it. There's also a historic tax credit if the project happens to involve the renovation of certified historic buildings that were built before 1936, then that rehabilitation tax credit might apply. And similarly, there's something called tax increment financing. This and tax abatement are additional tools used by municipalities to promote economic development. We're finding more and more that things like tax increment financing and other tax abatement tools are being used not so much in regional centres, but actually more for direct EB-5. The problem with direct EB-5 investments is they're usually smaller. They often involve a single investor or just a few investors, rather than the EB-5 regional centre projects, which in some cases can involve 1,000 to 1,500 investors, obviously far more cash that's coming into the project. As I've already indicated, and this is really by way of introducing Richard, the immigration laws of the United States refer to aliens as immigrants, non-immigrants, and undocumented illegal aliens. Well, just to put that into context, anybody who comes into the USA as a permanent resident, which would include the EB-5 program, the moment they set foot in the United States with their visas and declare domicile, are going to be subject to worldwide taxation rules and regulations of the United States. I'm not going to go through residency rules and the residency test. They're there on my slides really for the sake of completeness. But as Richard is going to be talking about these, I shall perhaps finish my presentation just by saying that even an undocumented alien under the immigration laws who passes a substantial presence test could be treated or will be treated for tax purposes as a resident alien. As I say, immigration and tax are two completely different concepts under the rules. You'll pay tax irrespective of your status in the United States if ultimately liability exists. It doesn't necessarily mean, however, that you'll be treated as somebody who is entitled to remain or work in this country. And finally, and perhaps for high net worth individuals who are the subject, I think, of this seminar, timing is going to be important. If you're an immigration attorney like me, or if you're ultimately going to be advising clients when they should arrive in the United States, then obviously it's important to determine when to obtain a visa and when to effectively, I think there's a mistake on the slide there, but when to obtain the visa and when to declare residence. So for instance, if you're obtaining a visa, it's only going to be valid for 6 months. If you obtain your visa in May, then you're going to have to come to this country and declare domicile in December at the latest, which means, of course, that you may be subject to taxation for that year. So wherever possible, we do try to plan and work with our clients to ensure that although there's always an urgency in obtaining visas, the visa itself is obtained in such a way that they can move into the next tax year if that's going to be more advantageous. And so with that, I'll introduce Richard.
Thank you, Anthony. Are we good on
Yep, you're ready to go.
Oh, okay. Okay. All right. I'm going to discuss today the tax planning for immigrants that we're going to define whether you are a U.S. taxpayer or a non-resident alien taxpayer. We're going to talk about how, in advance of coming here, we can do a lot of things to make sure that people are not paying on their accrued wealth, where in another country they've worked all their life and they come here and can find that they haven't done the right thing, and they have a lot of capital gain from 25 years ago that they're now going to have to pay tax on in the United States. So we're going to define the taxpayer we're talking about and define the 4 different categories of where we can do some tax planning for them. And I just want, just a personal level, I started to do a lot of this work many, many years ago, and I got woken up by an Ecuadorian art collector who had, for many, many years, lived in Ecuador and accumulated a lot of Ecuador Indian art that turned out to be very, very valuable. And he came to me too late in the game. It was whatever year it was, 1980, let's say, and came to me the early months of 1981, and he sits down and tells me what happened, and I have to say to him, look, you didn't do anything to raise the basis of your art before you got here, and you have a sales price of whatever it was, $3 million. Well, guess what? You have a basis of $50,000. You've got a tax bill on $2,950,000, and that woke me up to this concept of pre-immigration tax planning. So let's move on. And the first lesson, and that's the one I just talked about, is you can't accomplish pre-immigration tax planning after the residency starting date. That's for income tax purposes. And we'll also, very late in the presentation, talk about for estate tax purposes. Now, how do we define the difference between a non-resident alien and a resident alien? The resident alien and the consequences. The resident alien is going to have several of the statuses that Anthony talked about, and they're also going to be here based on time, which we'll also explain, because time and state of mind has a lot to do with taxation for when it comes to non-resident aliens. Now, the resident alien is taxed just like an American, like a U.S. citizen, and that's a whole different area of tax planning. The resident alien is going to be subject to U.S. tax on worldwide income, worldwide assets, and gift taxation, with certain exclusions. How do we identify a resident alien from a non-resident alien? Well, there's three different standards, and then some exceptions to those standards. If you're not an American citizen and you have a green card, which Anthony discussed, permanent residency, you're going to be a U.S. taxpayer. Now, there may be the very tiniest of exceptions if we have somebody where we're in a country where we have a treaty with them, and there's a tie there, and we'll talk about that. But the green card is residency, tax residency. Then I'm going to skip to 3 because that's an easy one. You can voluntarily elect. If you're married, you can elect into being a resident, for example, so that you have the benefits of marital deductions and what have you. The third test that we're going to look at is what's called the substantial presence test. And this is a very, very objective test. If we have a tax treaty with a country, typically this substantial presence test is not going to be the real issue. But there's a lot of countries we don't have tax treaties with. And the substantial presence test is determining as a matter of how many days. Let me get this next thing. The substantial presence test is a matter of determining certain amount of days that you're limited to in the United States over a 3-year period. The permanency residence test is the green card, and the election is the election you make on your tax returns. The substantial presence test is where an individual you look at their 3-year history of how long they've been here in the United States, if they're not U.S. citizens or don't hold a green card, and there's a formula to determine whether a non-resident, whether an alien is non-resident for tax purposes or not. And the formula goes strictly according to a 3-year time period. What they will do, and now we're going to look at the left side of this chart and see the difference that we're talking about. On the left side of the chart, we're assuming that what you have is a formula where the year that you are looking at to determine whether you're a tax resident or not. In that year, you look at the time period that you've been in the United States, and the formula is that each day you've been here is counted as a full day towards a standard of having less than 183 days a year. So if you're here for 184 days in a year, in any one of those years, you're going to be a tax resident for U.S. tax purposes, unless, and we'll talk about this later, unless there's a tax treaty involved. So the formula is you kind of try to look at it as, well, you can spend 120 days a year in the United States because you go back, you look at the year that you're counting, which is day for day. Then you can go back and look at the prior year, and in the prior year, the amount of days that you were in the U.S. in the prior year are only counted as a third of a day. You go back 2 prior years, and for determining now whether a taxpayer has a substantial presence in the United States and is therefore going to be subject to U.S. taxation, you add up these dates according to the formula. So you'll see on the non-resident alien side, there's 120 days in the year we're looking at for determination. There's 120 days, and only 1/3 of them, 40 days, are counted towards residency. And in the second year back, there's excuse me, only 120 residency days counted because they're divided by 6. When you look over at the resident alien side, you'll see that in 2016 there was 150 days in that year, and you have a total of 190 days, and the failure of the substantial presence test. So someone in the right-hand category who is not in a country that we have a treaty with is going to be subject to a United States full income tax. We'll get into the estate tax side in the end, but the United States full income tax, the same as a U.S. citizen for that year. As we discussed, the other way you become a U.S. taxpayer is the residency, getting your green card. And in getting that green card, there's some careful dates that people have to look at when they are handling their tax planning, because the standard for it is the first day that you're on for counting what we'll get to in a minute. The first day is the day that you get your green card and you're standing on United States soil. And there's been stories of people who really needed to get their act cleaned up within the next 6 months, got their green card, and went into a U.S. embassy. And they were standing on United States soil, and they were U.S. taxpayers from that point on and couldn't do any kind of tax planning. So this residency starting date is something that really is worth taking some notes on. And what I did here was I tried to show the difference between the residency starting date and the substantial presence test. This is two examples I'm going to give us. The first assumption, we have a non-resident alien, doesn't have a green card, not a U.S. Citizen, and he is not in the United States for 2016 or 2017 at all. That non-resident alien, then there's a second non-resident alien who was in the United States the resident alien was in the United States for the year 2009, and in the year 2009 he had no carryover dates because he wasn't in the U.S. for 16 and 17. In 2009, he was in the United States, or she was in the United States for 46 days between January 1st and the middle of February, went out of the United States, came back in the United States from August 31st to December 31st, and over the 3-year period did not have 180 days. So he wouldn't be considered to have been a taxpayer under the substantial presence test, but he or she is a taxpayer because the green card was issued on August 31st, and that's the first time that this taxpayer was on American soil on August 31st. So that's the one look at the residency starting date. Now we're assuming a non-resident alien, again, no time in the United States, 16, 17. And this non-resident alien comes in on January 1st through 2018, spends 46 days here, doesn't get the green card until August 2018, but has spent 199 days in the United States for 2018. The green card was issued on August 1st, but the person was here and failed the physical presence part of the residency test. And that taxpayer doesn't start when his green card is issued. It starts when he or she is in the United States for the first time in that year. So that's how we kind of identify non-resident alien taxpayers, people who have been here for a certain limited amount of time, that don't have green cards, not U.S. citizens. Now, there's a couple of exceptions to what I just spoke about, and the exceptions are there because the Treasury is basically trying to let the people who are in tax treaties and the people who don't have tax treaties have some kind of similar treatment on whether a taxpayer is a non-resident alien for tax purposes or not. And we'll see in a minute that the tax treaties are not really that strict. They don't have a particular amount of days. So in the U.S., in trying to give people who don't have tax treaties, trying to give them at least some leg up, have come up with what they call the closer connection exception, which allows a non-resident alien to stay in the United States for up to or fewer than anytime fewer than 183 days, and have almost a full half year here without being considered a U.S. taxpayer. And the closer connection exception is basically the taxpayer has to have a home outside of the United States, has to have all the indicia of what we would call a closer connection. If there's most of his family is outside of the United States, where his business is, if most of the religious centers that they go to, but how many people work for them in the United States versus outside the United States. And if you have a closer connection to the United States, to your foreign country, then you're allowed to be in the United States for 182 days without violating any residency standards. We covered the closer connection, and that's where it's you can get your full 182 days every year, not have to look at the 3-year history at all, and that is a rule that, as I say, they were trying to get some parity with countries that we have treaties with. Now, the other exception to, and in certain instances, is even stronger than having a green card. It's a pretty limited area, but is that we have tax treaties with, I think it's over 60 countries throughout the United States. And those tax treaties have their own standard of whether, like, you're a taxpayer in Russia, or whether Russia is your primary tax place, or whether United States is a primary. And there's a lot of people, especially in today's world, where they could be either one of these. So with what they do when we have a treaty situation, we try to determine what is the person's true residency, but we use a different standard than the very objective standard of days. And the standard that we're using there is really where are they doing the most that they're doing? If you're 182 days in the United States and 182 days in Russia, you've got to have some kind of standard to figure out who gets the taxpayer, the primary taxpayer. And these treaty tiebreaker rules go through a series of things where basically it's like the residency test of where's your business, where's your home, and if you go through all of that and it's all a tie, if you got business in both places, a home in both places, some family members in one, some in another, then you wind up going to the tax authorities to let them decide who's got the real hooks into you first, and then where you a non-resident taxpayer. Now, there's also some exceptional circumstances that a lot of this I've seen get abused, and that is students who meet a certain standard are not going to pay any tax on anything but their U.S. source income, and which is if they're working here, and so students basically can make money outside of the United States and not have any U.S. source income, and still benefit from not being a U.S. taxpayer, even if they're here for 365 days. And it's I think it goes for about 5 years, where it's pretty standard, and then after that, it's got to be shown that there's a real good reason for that. But students have the benefit of paying no taxes. And, I mean, I kind of laugh at this because I had one client who was from Venezuela, and the wife was going to a 2-year cooking classes at a university. And the husband came in as under the student visa, and the husband is making $1 million a year in Venezuela in the banking business. So this is something that is used, maybe a bit overused. So this is just a quick review. The effect of treaties, how treaties are not really governed that much by the time. Of course, it becomes obvious that if somebody is from Russia and they're in the United States for 10 years, for 250, 300 days a year, it's going to be hard to say that your tax residency is Russia, but it may be. It might be your family's over there. Everything else is over there. So the effect of treaties, we looked at the substantial presence test, the closer connection exception, and some other exceptions. And now what we were going to look at is the 4 income tax objectives, and then we'll get to the estate tax objectives. The income tax objectives are, I'm going to show each one of them really by a simple example. You want to make sure that a non-resident alien who is becoming a U.S. taxpayer, whether it's because of substantial presence test, the treaty, and green card, what have you, you want to make sure that the fullest extent possible, just like this art collector, that you accelerate any of the capital gains, any kind of gain that you want to accelerate And I use the example of, and you don't really have to alienate these properties. You don't have to sell them most often. But I use the example of you have Ford Motor Company, and you bought it at 20, and now it's 40, and you can sell it at 20, buy it back at whatever $20.01, and come here and not pay any tax on the gain. It's as simple as that. It's when you're talking about acceleration of income from foreign sources, it might be as simple as accelerating a dividend, just giving somebody their year-end dividend who's going to be a U.S. taxpayer on August of the coming year. Give them their dividend instead of the end of the year. The next item that we're going to want to do when we're talking about, and I'm just giving you the simplest of examples here, is deferral of loss recognition. What if it's opposite with the Ford stock? Why sell it when you're a non-resident alien, have no use of the capital loss? If you can wait a little while, become a U.S. taxpayer, sell it, and now there at least you got a market risk where you don't have it on the gain side, but you can take your loss and use it when you're a U.S. taxpayer. And the next item, last item, would be deducting expenses, the deferral of expenses into the future, such as holding on to an invoice that you're being underpaid on and losing money, sending it out, losing the money after you've got your U.S. taxpayer status, as opposed to be going after it and writing it off before. So that's kind of the simplest of all of my examples, and it's really all up here. The non-resident alien will want to make sure that he or she does not have to pay U.S. tax on any gains that are accrued or, as a practical matter, can be accelerated before their residency period. The second key strategy, accelerate income that is expected to be paid after residency, and the same thing for losses. Defer recognizing loss until after obtaining the residency status and being able to use that loss. The fourth is deferring expenses. Now, I have a couple of examples on this. Assume a non-resident alien had $1 million worth of General Motors shares. This is the one we went over with, and was purchased for $950. If the shares are sold after U.S. residency is assumed, when the immigrant is a resident alien, there'll be a tax on 950 gains. The sale of these same shares prior to this would result in no gain. We are looking at this one was kind of interesting, accelerating income prior to the residency starting date. Now, there's simple things like paying your bonus or what have you before you're a U.S. taxpayer. But I had a situation where there was $2 million in receivables in a company that the receivables weren't going to come in for quite a long time, and the taxpayer was right in the middle of becoming a resident. He was going to sell part of his business later on, and instead we sold it and turned the receivables into a note receivable that where we already had a basis in it, and we had a new residency starting date, and instead of a receivable, we had a promissory note. And this kind of is works best for non-resident aliens because they actually can't, not even allowed to, have the installment sale. So they've got this accelerated basis right from the start there, without having to really do much more. When it comes to income assets to accelerate, pension plans, stock options, prepaid rent, prepaid royalties, prepaid dividends, prepaid interest, annuity products, whatever's going to be accumulated wealth, you don't want to be paying a U.S. tax on it. And the same goes for accumulated loss. You don't want to be losing the value of that loss. And so this was just another example that goes into the loss idea. Now, I'm just going to go through this. Now we're going to. How much time do I have?
You have about 10 minutes.
Okay. All right. We're now going to switch over to and you know what? Maybe what I will do is I want to look at some of the sophisticated things that we can do to accomplish our goals here. I did talk about the receivables, but I also had an interesting case a couple of years ago where there was a gentleman who had Venezuelan corporations owning pieces of real estate in Venezuela, and he was going to get trapped because he had a very low basis in his shares of his Venezuelan corporation that owned that real estate. He had set these companies up years and years ago, and he was going to be stuck with the trap of not being able to not being allowed to collapse the Venezuelan corporations, really not being allowed to make too much of a change to this. And I almost want to say we stumbled across the fact that wait a second. I'm just trying to get this slide. Yeah, that when I don't have that, but when all we had to do go from, and this change was allowed. We had to go from being Venezuelan corporations that had all of this locked-in gain that really couldn't be shed, and go to a Venezuelan, the same type vehicle. It's a limited liability company, which was, for our purposes over here, was the liquidation. The guy wasn't a U.S. taxpayer yet. There was a liquidation before he became one, and the gain was realized in Venezuela, and the Venezuelans had almost the same kind of entity. It wasn't, they didn't want to have United States entities in there, and from the Venezuelan side, they had a limited liability company instead of a stock company. From the U.S. side, if he became a U.S. taxpayer here, he had an increase in basis and acceleration because of the liquidation of the company. So that's some of the things that you can really get your teeth in. And I'm just going to close it up with looking at the estate tax, because when it comes to the estate tax, and this one is really important, there's a lot of people that are not woken up to this. And a residency for estate tax purposes, first off, is not the same as residency for income tax purposes. You've got your objective standards plus your treaties for residency for income tax purposes. Residency for estate tax purposes is a much more permanent intention. It's a permanent state of mind, along with the physical presence. And there's many cases that go in all kinds of ways. I mean, there's cases of men who stayed here for 10, 15 years waiting to go home before wars ended and things like that, and always being able to say, I always intended to go back. I have some factories back there and what have you. So when we have an issue with any kind of estate tax on people and bringing in estates where they run into non-resident alien status, well, we have the problem of non-resident alien status having an exemption or deduction of only $60,000 before you start an estate tax. Wait a second now. Off the screen again. Okay. Right. I want to get back and just finish off this estate tax, and my screen dropped again. These estate tax cases can get very, very complex because you are looking at state of mind along with presence. And there's going to be more and more big dollars here that typically is going uncollected because you've got tons of non-resident aliens coming into the United States now, and not a lot of knowledge about the estate tax, and if they do come here and are pushing the envelope too far, let's say, you can find I'm in South Florida. There are so many Russians in South Florida who have overstayed their visas, for example, who really like it here and don't want to go back, and they could have estate tax problems, even though they have billions of dollars in Russia. And the estate tax is your presence and your state of mind in the United States. And the more you're here, showing that you're not about to go back and leave here, you get closer and closer to paying the United States estate taxes on if you have a lot of foreign assets that you haven't dealt with and cleaned up the gain and what have you. You come here and with a lot of low basis assets and get caught up in the U.S. estate tax if you're here with some degree of permanency. So you really have to, somebody who's coming here, it's more than just the income tax side. It's the wealth side from the standpoint of the U.S. estate tax. Now, with the new Trump tax bill, the window has gotten a lot bigger for the exclusion. But we've got, from my experience, we have a lot of very wealthy people coming here to the United States, getting close to that blurry definition of are you a resident alien for estate tax purposes? And that's all I've got. So thank you.
Thank you so much to our speakers for your insights today. A brief announcement. New York State requires that you record and report the following code in order to obtain CLE credits for the live or recorded version of this CLE webinar. If you'll be requesting CLE credits for this seminar, please write this code down. The code is TLEXFA. That's T like Tango, L like Lima, E like Echo, X like X-ray, F like Foxtrot, A like Alpha. Again, that is TLEXFA. Now on to our live question and answer session. Listeners can ask our speakers any questions relevant to today's topic. You may email questions to taxlaw@straffordpub.com. Submit questions by typing your question into the Q&A box at the bottom of the screen and hitting enter. And you may also ask questions by telephone. To do so, press *# on your touch-tone phone. Again, that's *#. After you press *# and when it's your turn, you will hear your microphone has been turned on and you have the floor. If for any reason you decide not to ask your question, you can press *# to exit the question queue. I'm going to go ahead and turn the floor over to Anthony. I believe, Anthony, you have a question for Richard to start us off. Anthony, are you on mute?
Yeah, I can't hear anything.
Sorry, can you hear me now?
Yes.
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 That's good. I'm sorry, Richard. I must have been on mute.
Sure.
When an EB-5 investor or indeed any other permanent resident arrives in the United States and declares domicile, so the date of arrival obviously is relevant to the issue of taxation. Let's say somebody arrives in June. Are they liable to pay tax on the entire year, or is it prorated according to the date of arrival?
You're talking income tax.
I'm talking income tax.
Yes. Now, okay. Yeah, I my estate tax thing. Ask me that again.
Okay, so the moment a permanent resident sets foot in the United States and declares domicile, they become subject to the U.S. taxation regulations. My point is, if they come halfway through the year, they're obviously going to qualify, or they're going to be liable for tax in that tax year. But is it prorated from the date they arrive, or are they liable for tax for the whole year?
Well, it depends. That was one of the slides that I messed up a little bit. If they have stayed here under the substantial presence test, let's say, and they've accumulated more than 182 days, then it's going to run the whole year. If they were short on that, then it wouldn't start until they got their green card.
Got it. That's okay. I understand. Okay, so it would be relevant as to whether, let's say, they'd been in another country, let's say China, waiting for their visa. They came to the country. Their domicile is declared on the day they arrive. Provided they haven't spent 180 days in that tax year in the United States, then they're going to be prorated. But if they've already spent, or if they spend 180 days during that tax year, then they'll pay tax for the whole year. I get it.
Right.
Thank you.
Right.
Thank you.
Mm-hmm. Oh, welcome.
Excellent. Thank you both. Our next question says, when an EB-5 investor receives his conditional green card, is he at that point subject to worldwide taxation and files a 1040?
I think we've just dealt with that. So the investor will not be subject to worldwide taxation on the date of receipt. The date that you receive a green card or a permanent resident card is irrelevant. It's the date that you arrive in the United States and declare domicile. In other words, you arrive with your visa and you become a permanent resident. Alternatively, if you've adjusted status in the States, you become a permanent resident on the day that your application is approved. So receiving the card is perhaps a little confusing. That doesn't usually arrive until several weeks later. But it's the date upon which you become a permanent resident that's relevant for the taxation issue.
Thank you, Anthony. We do have a few more follow-up questions. If the investor receives the conditional green card while in the U.S. and stays in the U.S. for a month, then returns to China, what happens then?
Well, Richard, do you want to take that one?
I would say that's that might be all right. I have to double check this, but that scenario of really kind of not being here. I would think that there's going to be a good case to be made that his closer connection is China.
There's a problem there, though, Richard, in the sense that this is where immigration and tax are incompatible.
Okay.
So from your purposes as a tax attorney, you'd have a very strong argument for suggesting that that person wouldn't be liable at that point to U.S. taxation because of the close connection provisions. My issue would be that I have to show that that person has become a permanent resident and has actually then made the United States his or her principal place of residence by virtue of being a permanent resident. And so I think the immigration aspect of that may be overriding. They're incompatible. Clearly, the taxpayer doesn't want to pay tax, But from an immigration perspective, they want to make sure that their conditions are going to be removed 2 years later.
Right.
And one of the questions that's asked by immigration when you file the I-829 petition after 2 years of residence is, have you declared non-residents for tax purposes? And that's a big no-no from an immigration perspective. So while the answer may be that you can avoid paying tax from an immigration perspective, if you do so, this may prejudice your future status.
Thank you. There is a follow-up to that question. If they arrive in the U.S. and then return to China after a week, have they met the arrival test to be required to file a 1040 and report worldwide income?
Well, if we're talking, I guess they
I think it's the same answer, Richard, isn't it? From an immigration perspective, they're here. I mean, once you've arrived and you've declared domicile as a permanent resident, you are then a permanent resident. So immigration requires you then to act like a permanent resident, which is to file tax returns. Right. You would need to speak to a tax attorney, somebody like Richard, who'd have to consider your case carefully to decide whether or not there are certain exemptions and other things that can happen. But Richard, in those circumstances, would have to work together with an immigration attorney to make sure that what he does is not inconsistent with the permanent resident status. So I think there's no black and white answer. The black and white answer is that you are liable to taxation. The grey answer is if you see a decent tax attorney like Richard, he may be able to minimize that, but he has to work in conjunction with the immigration requirements.
Okay, thank you. And the next one may be more of a statement. There is something called a dual status tax return, where an NRA will arrive in the U.S. and continue residency until the end of the year. Residency starts as of the first day of arrival. They are not considered a resident for the full year. Anything you'd like to speak to with that?
No, I mean, that's accurate. I think that's what we were talking about.
Okay.
Yeah, I mean, I think it's the same issue. Again, you may well not be regarded as a resident for tax purposes if you arrive, later in the year. But from an immigration perspective, it's going to cause difficulties later on if you try to avoid that tax liability. And that's why I think, one needs to be very careful. Rather than arriving in the second half of the year, if it's possible to do so, it may be better to delay arriving until the 1st of January. If you arrive on the 1st of January, there's no difficulty, you're taxed for that year, you've arrived in that year, and you've avoided any of the complications that might arise in the last 6 months. It's going to be harder to achieve that if you're already in the United States, let's say on a non-immigrant visa, and you're adjusting status. You don't really have any control over when that's going to be determined by immigration. But if you are a foreign national living in a foreign country, then I think it's better to wait until the beginning of the tax year before coming here and declaring domicile, if it's possible to do that.
Well, yeah, I mean, it gives you a much more clear-cut cutoff point. But I know we do a lot of where people are not waiting, and that's where you have to kind of choose a cutoff point and gather all the evidence you possibly can to say, okay, this is the time they became a tax resident, and here's the proof of it.
Yeah, I mean, in my experience, people are impatient in the sense that they want, once they have their visa, they want to arrive as quickly as possible. But I do counsel all my clients, particularly those who will have, quite serious tax implications, that if it's possible to delay coming until the 1st of January, then do so. Because, like Richard says, it's much cleaner at that point, and you can say that's the cutoff. Then you're liable for tax on that year and not from the previous year.
Right.
I mean, there may also be reasons, of course, why you may want to arrive in the previous tax year. We're looking at this from the tax liability perspective. There may also be tax credits. You may have made a massive loss the previous year, which you want to write off. That's also going to be a reason why you may want to come earlier. Would you agree, Richard?
Yes, yep.
All right, gentlemen, it looks like we have a couple more minutes and no further questions. Do you have any other takeaway messages you'd like to give to our audience today?
I think from my perspective, if anybody is interested in the EB5 program, obviously look carefully at what's going to be happening at the end of this month. First of all, whether the Regional Center Pilot Program is going to be allowed to sunset, whether it's going to be extended or renewed. If so, whether there are going to be any changes to the minimum investment amounts, to the way that targeted employment areas are going to be determined, and indeed any other changes, regulatory changes that are likely to come in. Beyond that, I think that's really all I have to say.
From my standpoint, I'd just like to comment that I've seen so many close calls in the estate tax area with non-residency and residency, and I think it's wise not to get in the close call area because state of mind and residency is after somebody's passed away and you're trying to decide state of mind, it's not easy to do, and it can really be problematic when you're dealing with large sums of money today. I mean, the people that are coming in, at least the investors that are coming in here, they are bringing big money, and they've got to be careful of exactly how to handle this stuff.
I think what we're both saying is prevention is better than cure.
Right. Yeah.
Excellent. Thank you, gentlemen. And with that, we will conclude our Q&A session. We do hope that you've enjoyed our national webinar, Pre-Immigration Tax and U.S. Investment Planning for High Net Worth Individuals, Navigating the EB-5 Investors Visa Program, Leveraging Tax Credits and Avoiding Tax Traps. If your question was not answered, you may email it directly to our presenters. Their email addresses are included in the presentation materials. If you're seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to the form will be included in the thank you email that you will receive immediately following the program. As long as you've registered and paid for this program by 5 p.m. today, you'll receive your certificate of attendance within 24 hours. If you have any questions about continuing education credit for this webinar, please call our Continuing Education Department at 404-881-1141, extension 2. Again, for those of you seeking standard tax or accounting continuing education credits, you will need to have responded to all of the pop-up prompts. Today's participants can order a recorded version of this event at a special attendee price. Please call customer service at 800-926-7926, extension 1, or visit Stratford's website at www.stratfordpub.com. If you're not yet a Stratford Annual Pass holder, try the CLE Individual Annual Pass. You can get all your CLE credits for one low price. Simply respond to the email when you receive after the program. Stratford would like to thank you for your attendance. To end this call, simply hang up the phone. Thank you and goodbye.